Thank you everyone for joining. Um, the course remains ENT 81811. The course remains ENT 811. And we have been covering a couple of topics. The course is e-business and event management. We've been covering a whole lot of topics since we started. We've talked about e-business and the internet. We've talked about e-business and websites. We've talked about e-business and advertisements. We've talked about e-business and security. So today, we'll talk about copyrights. Copyrights as it concerns e-business. Anyone that wants to go into e-business must understand um, must understand the meaning, the need for copyright. So, as a way of introduction, today's topic is copyright laws and electronic access to information content. And we expect that every student should be able to define and know the concept of copyright at the end of this session. Every student should be able to, to a large extent, trace the history and the development of copyrights. Every student should be able to answer the question of what is the scope of a particular copyright, as well as the justification in applying copyright to a particular intellectual property. Every student should be able to obtain and enforce copyrights in whenever there is a violation or someone is impeding or is using your work without your authorization. We also want to say that every student should be able to explain the limits and expectations of copyrights. Okay, let's start. Now, what do we really mean by copyright? What do we mean by copyright? Now, historically, uh, copyright is a type of, okay, let's just do it this way. Let's explain it this way. Copyright is a type of intellectual property that gives its owner the exclusive right to copy, distribute, adapt, display, and perform a creative work, usually for a limited time. All right, it's just like getting an authorization to use what is not yours. That is a kind of copyright. However, copyright is also getting an authorization to own what is yours totally. So it's this property, this writing is yours, this creative art is yours, this music is yours. You now go and get an authority, an authoritative sort of authoritative seal upon it that says that I'm the owner of this and I'm the one that has the exclusive right to use it, to copy it, to distribute it, to adapt it, to display it, and to perform with it within a certain level of limitations that the laws have created. Now, copyright was invented after the advent of the printing press and with wider public literacy. Of course, once the printing press came into being, literacy became a concern because once you keep printing, people need to know how to read what you are printing. And then once there's an access to printing, there is without laws, there is an unlimited access again to unlimited copying of such things. So copyright came into existence because of this. As a legal concept, copyright as a legal concept, its origin was in Britain, where from a reaction of printers, they tried to monopolize the landscape, the printing industry at that time. They tried to monopolize at the beginning of the 18th century, the printers. So Charles II of England was concerned with the unregulated copying of books and passing the Licensing Act of 1662 by Act of Parliament, which established a register of licensed books and required a copy to be deposited with the stationers company, essentially continuing the licensing of materials had long been in effect, though they licensed things before, but copyright just came into being at that time. Now, the British Stater of Anne in 1710 further alluded to the individual right of author of a particular work. That's the beginning. Whereas printers, booksellers, and other persons have of late frequently taken the liberty of printing books and other writings without the consent of the authors. The stator Anne was talking about that. So she still continues saying that to their very great detriment, this copying is affecting the authors, and too often it tries to ruin them and their family. Of course, I can add my own quote here that the British state of Anne was talking about people copying people's work, denying them of the benefits, both economic and so on. So, and it was to the detriment of the authors. So a right to benefit financially from the work is articulated, and court rulings and legislations have recognized a right to control the work, such as ensuring that integrity of it is preserved, an irrevocable right to be recognized as the work's creator appears in some countries' copyright laws. Now, the Status of Anne was the first real copyright act. The copyright has grown ever since that time to cover several areas like copyright for maps, copyright for industries, sound recordings, films, photographs, softwares, architectural works, books, and all that. Now, let me just say this before I continue. The copyright is an important thing, very, very important, because if not for the copyright, some particular act works will be out of circulation now. Because if you go through the copyright laws, there's a part of the law that says that after a while, a work has been copyrighted, and after the death of the owner, there is a particular time frame the work now becomes sort of free. Now, it depends on the jurisdiction where you're working, where you're viewing copyright from. In Africa, the copyright laws are slightly different. Europe is different. America is different. Country by country, there are slight differences here and there. So it's important to understand these differences so that you understand what the copyright is all about. Now, the Copyright Clause of the United States Constitution of 1787 authorized copyright legislation, and it states, to promote the progress of science and useful arts, that's what copyright was for, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. That's what that copyright statement in the United States Constitution stated. It's a right to promote from the work. A right to profit from the work has been the problem for much legislation extending the duration of copyright to the lifetime of the creator and beyond to his heirs. So you see, in the US, they can extend the copyright beyond the lifetime of the person that created it. But in some countries, once the person that created such work passes on, such work becomes free. Now, in 1886, the Berne Convention, it was first established to recognize, or it's first established recognition of copyright among sovereign nations was the 1866 Berne Convention. Under the Berne Convention, copyrights for creative works do not have to be asserted or declared, as they are automatically enforced at creation. That is, once you do the music and it can be proved that you are the one that did that music, automatically this Berne Convention says you are already the copyright owner. So an author need not register or apply for a copyright in adherence to the Berne Convention. So all the nations needed to do at this time was subscribe to this particular convention and the rules that concerns copyright, and these laws were applied in their countries. So this Berne Convention was first established the copyright laws among sovereign nations in 1886. You see, it was a little bit earlier, later than 1787, which in the time frame in which the United States established theirs. Now, in the UK government decided to sign in or subscribed to the Burns Convention in 1887, but did not implement large parts of it until 100 years later. That's quite some time. With the passage of the Copyright Design and Patent Act of 1988, can you imagine? 100 years later, they decided to start implementing it. Now, the US did not sign the Berne Convention until 1987. So up to 1989, up to 1989, they were operating their own laws, which was essentially to promote the progress of science and useful art by securing for limited times to the authors and inventors the exclusive right to their respective writings and discoveries. That was what the US was doing, and some other laws attached to that. Now, the United States and most Latin American countries instead entered into the United States did not sign the Berne Convention until 1989, while United States and most Latin American countries instead, that is prior to that time, entered into the Buenos Aires Convention of 1910, which required a copyright notice, meaning such as all the rights reserved on the work and surrounding nations to limit the duration of copyright to shorter, renewable terms. The Universal Copyright Convention was drafted in 1950 as another less demanding alternative to the Burns Convention, and it was ratified by nations such as the Soviet Union and developing nations. All right. Now, like I said, the copyright laws were changing according to where you find yourself, the nation you find yourself, the part of the world you are in. So, copyright, what are the scope of copyright? Copyright may apply to a wide range of creative, intellectual, or artistic forms or works. Specifics for these vary by jurisdiction, that is, from nation to nation, from continent to continent, from environment to environment, and from times to times. So the specifics of copyright varies by jurisdictions, but these can include poems. Some countries may not include poems, but poems, theses, academic theses, plays, other literary work, movies, dances, musical compositions, audio recordings, paintings, drawings, sculptures, photographs, softwares, radio and television and broadcast. So copyright does not cover ideas and information themselves, only the form or manner in which these ideas are expressed. So because you can't just copyright an idea comes to several people at several times. So one person cannot own it up. It's only that person that has converted that idea into a particular form. He can now copyright the form in which his idea is being implemented. So you should understand this. Okay. Now, we say only the form or the manner in which they are expressed can be copyrighted. For example, the copyright to a Mickey Mouse cartoon restricts others from making copies of the cartoon and creating derivative works based on Disney's particular anthropomorphic mouse, but doesn't prohibit the creation of other works, other kinds of mouses, about the anthropomorphic mice in general. Some of us have some cable televisions that broadcast children cartoons in our houses, and we must have seen different kinds of mice of different shapes and sizes, which is not the Mickey Mouse cartoon replica. So they copyrighted their own cat, their own mouse, and all that. Others that came up with their own came up with different designs, but there are different mouses and all that, and those ones copyrighted theirs. So it's the form and the manner in which you express that idea can be copyrighted. Now, these are the scope. Now, what is the justification for copyright? Why is copyright being done? Why do we say it's right to copyright something? As with patents, patents apply to physical objects. Like for one of us that is producing maybe a particular soft drink, you have to patent it. You are producing a particular kind of diaper, you have to patent it and all that. As with patents for physical objects, The granting of copyright was ensured by government to promote innovation and guarantee first to market protection, So once you get to the market first, the copyright tends to protect you from others that are willing to copy your work or are intending to copy your work to bring you down. All right. So the first to market protection for the owner of the copyright. Historically, more likely the publisher than the creator. Now, do you know why they say it's more likely the publisher than the creator? Most times those that write may not have the money to publish. So they may be approached by publishing companies and say, okay, this book you have written, this novel you have written, we'll publish it for you. We'll take the cost, we'll bear the burdens of the cost, and we share the profit 80-20. Or we'll just pay you an outright 200,000 for this your write-up, and then you sign a document for us. We will be the ones to type it, print it, publish it, go through all the editing, register it, and then we sell. Whatever we get is ours. So you see, once the author signs that document, he signs off his right to ownership of that to the publishing company, and the company becomes the copyright owner. Now, this is the government, for example, government-sponsored monopoly does provide innovation and great benefits to society as a whole. When government becomes a monopoly, it becomes good for the country. Let me give you an example of a monopoly. Of course, in Nigeria today, the railway system is solely run by the government. That is a monopoly. Government at that level is not intending to make profits. Its intention is to provide transportation, ease of moving materials and human beings from place to place throughout the country to boost the economy, to ease movement and all that. So you see, when government takes up monopolistic positions in terms of this kind of train system I talked about now, it is for the innovation and for the general benefit of the society as a whole. But the government allows for catalytic or capitalistic pressures after the first to the market advantage has been provided as a reward. For example, the government has come into the market as the sole owner of the train. It has done that. The government doesn't profit, so it doesn't worry itself about it. But what about the first person to try to join the government? The government gives that person a kind of room to bear a lot of cost, as well as a lot of room to get a lot of profit from it before others will show up. A typical example of this was when the government was issuing licenses for telecoms. The government had a landline and government was a monopoly. And so after that, the government went into GSM. All right. After going into the GSM market, it now gave licenses to MTN, to Econet. Econet was first, MTN was second. Then I think government had 0804, which was government that time. So what government did, just like the copyright, they gave them exclusive rights to run that license for a period of time so that they can recoup the money they've invested. Why? Because once you are a market, once you are the first to the market, you are going to encounter a lot of challenges. You are going to break a lot of glass ceilings. You are going to be affected by a lot of hindrances here and there. So they will give you time to weather that storm and make your money back. Subsequently, if other people come into the market, they will not face such challenges. So they don't need that exclusive right like the first people that comes into the market. So this is just an explanation of this kind of government reasoning, where after the first person has been protected, they now allow other capitalistic investments to come in. That is after the first to market advantage has been provided as a reward for the first person to come in to the market. So some critics claim copyright laws protect corporate interests while criminalizing legitimate use. That's for critics. I don't know why they are doing that, but everybody has a perspective to things. But alpha are those works that were protected for so long that original owners is no longer alive. So those work becomes orphaned. That's the word they use in qualifying them. You use copyright to protect this work from copying. And all after a while, the owner is dead, meaning he's not producing that work again. And nobody can produce it again. So they call those kind of works orphan works because nobody can produce it. If you produce it, you'll be arrested. So those orphan works are seen as justifiable losses to modern copyright. That's lobbyists say so. That they're trying to justify their position why you should allow them some room to copy. All right. So often product works are seen as justifiable losses to modern copyright lobbyists, equating them to an old chair or other form of property that has served its purpose and even if no longer economically viable, a copyright should be maintained in principle. So they are still saying that maintain the principle and keep the copyright there. But some other people on the other divide is saying if you keep protecting these things and the person that's providing it for us is no longer alive, the product will just go extinct. We can't use it anymore. So there are a lot of arguments here and there. So that is what we mean by what is the justification for copyright. Of course, we know copyright also protects items in their original form so that people don't change it, mutilate it, and start reproducing it, even if the owner is dead. So you see some real artifact, real originality of something, copyright is protecting it from being mutilated and sold. Now, obtaining copyright. You know, when we see this topic, you may be asking us as students of e-business and event management, what is the relevance of this topic to me? What's the relevance? The truth is this, we've talked about the internet and how you move around the internet to get information, the ease of doing business, selling your product on the internet and all that, using internet facilities here and there, security of the internet. One thing you are not very, very cautious of is that while you are trying to navigate the internet to sell your product, to package your product, you copy things here and there. If you don't understand copyright as a business owner, as an e-business owner, you will run foul of the law. You could be arrested, you could be prosecuted for using materials that are not original to you. That is why it's important to understand the extent of e-business and to what extent can you copy what is online and use it. I advise those that I talk to most of the time, when you want to use pictures, search for royalty-free pictures. Don't just copy pictures and use because you saw them on the internet. It looks like it's free. It's not free. Someone has it. And each electronic copy has a stamp or a trace or a signature attached to it. So no matter how you try to bend it here and there, one time or the other, those signatures will pop up and the owners will know you are using their product and they will come for you. And if you have a big business, you will not like the kind of litigation that will come from such. You will not like the kind of bad PR that will come from such. So obtaining and enforcing copyright, let's talk about this at this point. Typically, a work must meet minimal standards of originality in order to qualify for copyright, all right? And the copyright expires after a set of period of time. It depends on the country. Like we say, some jurisdiction may allow this to be extended, while some will not. Different countries impose different tests, although generally the requirements are low. In the United Kingdom, for example, there has to be some skill, labor, and judgment, all right, that has gone into it for you to own it. In Australia and in the United Kingdom, it has been held that a single word is sufficient to comprise a copyright work. In all countries where the Burns Convention standards apply, copyright is automatic and need not be obtained through official registration with any government office. Once you can establish you are the first to create it, automatically you own the copyright. Once an idea has been reduced to tangible forms, for example, by securing it in a fixed medium, such as a drawing, sheet music, photograph, a videotape, or a computer file, the copyright holder is entitled to enforce his or her exclusive right to it. However, the registration isn't needed to exercise copyright. in some jurisdictions, that is, in jurisdictions where the laws provide for registration, it serves as prima facie. That is the first line of action or first line of evidence of a valid copyright. All right. Now, and it enables the copyright holder to seek statutory damages and attorney's fee for such. Now, the original holder of the copyright may be the employer of the author rather than the author himself. Now, listen to this. You may be working for a boss, and when you enter that office, you sign a document that anything you do within the time frame you work in this office is for that company because you use company time to do it. So you now wrote a book and he can establish that the book was written during your time working with him. Now, that could be, now he's the employer that is now the copyright owner rather than you that is the author of such work. So if the work is a work for hire, for example, in the English law, the Copyright Designs and Patents Act of 1988 provides that if a copyrighted work is made by an employee of that employment, the copyright is automatically owned by the employer as a work for hire. That's the term they use in qualifying such works that were done by employees under the employer of an employer. Okay, now copyrights are generally enforced by the holder in a civil law court, not a criminal court. Now, but there are also criminal infringement status in some jurisdictions. While central registries are kept in some countries, which aid in proving claims of ownership. The registry is, of course, where you go to register your copyright, right? It helps you to claim ownership because when there's a contention, they go to the registry and say, who registered first? Say, I'm the one. So you are the one that owns the copyright. Okay, that is copying. Go and pay him compensation. So it helps to prove claims of ownership. Registering does not necessarily prove ownership. Ignores the fact of copying, even without permission. Ignoring the fact of copying does it necessarily prove that copyright was infringed? Because at times, someone may own a particular product, but it doesn't register it. Yet someone steals it and goes and registers it. So he now owns the copyright, yet the owner doesn't own it. So if you can prove that you owned it before the registration, I think you'll be able to take back your ownership from that person that registered it. It's going to be difficult to prove anyway. Now, there's a concept called the poor man's copyright. Now, it's a widely circulated strategy to avoid the cost of copyrights. Because to copyright something, you have to pay some money for registration, take some part of the product and go and submit in the office for archiving and for registering and all that. Some people can't afford it. But there's a concept called the poor man's copyright. It is a widely circulated strategy to avoid the cost of copyright registration, and is referred to as the poor man's copyright. It proposes that the creator sends the work to himself in a sealed envelope by a registered mail using the postmark to establish the date. This technique has not been recognized in any published opinion of the United States court. The United States Copyright Office makes clear that the technique is no substitute for actual registration. The United Kingdom Intellectual Property Office discusses the technique but does not recommend its use. Now, listen to me. Why is it called the poor man's copyright? When you send a mail through registered mail, when you send a product through registered mail, that company, that mailing company, has a date attached to the sent item. So what the poor man does is to use that to establish a date. For example, you had a unique product, you sang a very good song, and you are suspecting somebody may register it before you. You take that song, package in a CD, and send it to yourself, and then record the date and the item that has happened. At that point, make sure you write it. It is my song you are sending. You know, that way, even if someone takes that song and goes to the registry of the copyright and registers it, if you establish that that song existed before he registered it and you are the original owner, you could make a case in court. That is why they call it the poor man's copyright. I need you to understand the rationale behind it. He cannot get the money and the items and the requirements to register it, but he wants to establish that as at this day, I'm the one that did this for the first time. So he takes that material, maybe it's an artifact, maybe it's a drawing. He snaps it, he makes sure that they register it in that company, they take note of it, the picture is there, he sends it to himself, and the date is established. That's what we call the poor man's copyright. The United States and the UK have their own issues in recognizing it. But you know, now I've explained to you why artists or people do it. Now, what's the meaning of exclusive right? Most times you talk about copyright, is a concept called exclusive rights. Several exclusive rights typically attached to the holder of a copyright. It means only him can use this. He has the right to, only that copyright holder has the right to this item. That's exclusive right, exclusivity. Now, several exclusive rights typically attached to the holder of a copyright. So one of it is to produce copies or reproduction of the work and to sell those copies, whether it's a mechanical right, whether it includes something, sometimes electronic copies, distribution right, and so on and so forth. Another exclusive right that the copyright holder has is to import or export the product. Another exclusive right he has, number 3, is to create derivative works, that is, works that can be adapted from the original work. He has exclusive right to that. A copyright owner has exclusive right to perform or display the work publicly. That is performance right. A copyright owner has exclusive right to sell or assign these rights to others to use. Another exclusive right is to transmit or display by radio or by video, that is by broadcast, maybe through the internet and all that, such materials. So you see why these days social media has come and people are in infringement of copyright laws here and there. Someone has an artwork, he displays it in his gallery and does not want to put it on the internet. He is the one that has the exclusive right to display. You, because you have a smartphone, you think you are wise. You go to his gallery, snap his artwork, and post it on your page. Just be waiting. The police will soon come and carry you because you are violating his exclusive right, the artist's exclusive right. So it's important to understand this as e-business owners, what you do and what you should not do. Now, the phrase exclusive right means that only the copyright holder is free to exercise those rights, and others are prohibited from using the work without the holder's permission. That's what exclusive right means. Now, let's go to limits and exceptions to copyright. Let's start with idea expression dichotomy. Idea expression dichotomy. Now, there's this personality called Immanuel Kant. In his 1785 documented essay, he tries to distinguish the physical from the ideational form. Now, the thought evolved from the book that you can distinguish or differentiate the physical from the ideational form of something. Now, this distinction is of critical importance to the near constant wrangling between publishers, intermediaries, and the original creative author. The first sale doctrine and the exhaustion of right copyright law does not restrict the owner of a copy from legitimately obtaining copies of copyrighted works, provided that those copies were originally produced by or with the permission of the copyright holder. It is therefore legal, for example, to resell a copyrighted CD or book. This may mean, for example, that a copy of a book that does not infringe copyright in the country where it was printed will does infringe copyright in a country into which it is imported because their own laws are different. You know, what we just said here now may sound confusing to some people, but in some countries, their law says that if you buy a copyrighted product, by buying it, it becomes your own, even though it was copyrighted. So the owner has exhausted, that's what they call it, exhausted his right. exhaustion of rights, copyright law. So he has exhausted his own right. Now, when you buy it, you that own it because you bought it can now duplicate it. It does not apply in every country. That's why you see the disclaimer here that you can buy a particular product, copy a book, and does not require infringement copyright in a particular country, whereas you take it to another country and you'll be infringing on the law because this exhaustion of right does not extend to that particular country. Know where idea and expression dichotomy ends, so you don't violate the law. Another limit, another exception to copyright is the fair use and fair dealing concept. Copyright does not prohibit all copying or replication in itself, in its entirety. In the United States, the fair use doctrine, what does it really say? The fair use doctrine says that codified, this particular doctrine is codified by Copyright Act of 1976 as 17 USC number 107. And it permits some copying and distribution without permission of the copyright holder or payment to same. The status does not clearly define fair use. That particular law does not define fair use, but instead gives 4 non-exclusive factors to consider in a fair use analysis when you want to analyze fair use. And these are the factors. The first is the purpose and the character of the use. Number 2, the nature of the copyrighted work. Number 3, the amount and the substantiality of the proportion or the portion used in relation to the copyrighted work as a whole. Number 4, the effect of the use upon the potential market or the value of the copyrighted work. You see where they now have an exception to the law. So if you're in that climate, be careful, know what the law says, know the extent to which the exception covers. In the United Kingdom, for example, many other Commonwealth countries as well, a similar notion of fair dealing was established. For US, it is fair use. For other nations like United Nations, Commonwealth countries, this is referred to as fair dealing. Fair dealing was established by the court or through the legislation. However, in Canada, private copying for private use has been expressly permitted by the status since 1999, meaning you can copy once you are not selling. That is in Canada. Okay. Now, another limit, another exception to copyright is the transfer and licensing. What does it mean? What does this concept mean? A copyright or aspect of it may be assigned or transferred from one party to another. For example, a musician who records an album will often sign an agreement with the record company in which the musician agrees to transfer all the copyright in the recordings in the exchange for royalties and other considerations to the record company. Now, the creator and original copyright holder benefits or expects to from the production and marketing capabilities far beyond those of the authors. Also, now, a copyright holder need not transfer all rights completely, though many publishers will insist you transfer everything. A transfer or license may have to meet particular formal requirements in order to be effective. For example, in Australian copyright law, copyright itself must be expressly transferred in writing. That is, you just cannot transfer it by just handing over your materials to another person. No, it must expressly be signed and documented. In the US, a transfer of ownership in copyright must be memorialized in writing, signed by the transferor, that is the person transferring it. A simple document that identifies the work involved and the rights being granted is sufficient. Now, similar legal rights. Now, copyright laws cover the creative or artistic expression of an idea. Patent law covers inventions. Trademark laws covers distinctive terms, marks, and names that are used in relation to products or services as indicators of original as does in a similar fashion trade dress. So for some of us that are doing business and you have a unique brand, you have a unique name, you have a unique slogan, copyright it, trademark it. All right. Now, registered design laws. The registered design laws covers the looks or appearance of a manufactured or functional article. Now, there's this uh, some people used to use uh, similarity of other people's product, they cash into it to sell their own. I don't know whether you have seen some in the 90s, those days, there was this set of radios, music players, they call them Sony players, Sony. That's the original Sony we know. All of a sudden, we started seeing Sony of Sonny, Soony. They sound alike so that they can deceive the customers to think it's the original Sony. Why is it so? It's because the original one is a market leader and is making a lot of sales. Now, just because it's happening here, maybe they will not be persecuted. But in some countries, if you do such, you go in for it, and you pay a lot of money to the original owner who has registered his own slogan, his own name, and all that. Now we also have trade secret laws. It covers secret or sensitive knowledge or information. Although copyright and trademark laws are theoretically distinct, more than one time of the more than one type of them may cover the same items or subject matter, so they can be interchanged in time to describe something. Now, what is the duration of copyright? Copyright subsists for a variety of lengths in different jurisdictions. The length of terms can depend on several factors, including the types of work the copyright is covering. For example, musical composition and novels. Whether the work has been published or not, it depends. And whether the work was created by an individual or a corporation, length of copyright also depends. In most of the world, the default position or default length of copyright is the life of the author plus either 50, 70 years. But in the United States, the term for most existing work is a fixed number of years after the date of creation or publication. So under most countries' laws, copyright expires at the end of the calendar year in question. For example, the United States used to require copyrights to be renewed after 28 years to stay in force, and formerly required a copyright notice upon first publication to gain coverage. While in Italy and in France, there were post-wartime extensions that would increase the term by approximately 6 years in Italy and up to about 14 years in France. Some works are covered by copyright in Spain for 8 years after the author's death. So you see in different jurisdictions, these things just change. Now, accessible copies. How do you access copyrighted materials? It is legal in several countries, including the United Kingdom and United States, to produce alternative versions, for example, in large print or brailles, of a copyrighted work to provide improved access to a work for blind and visually impaired persons without permission from the copyright holder. You see, this is an exception. Access to copies. Some countries give the access to copies, they make it open once it applies to the blind and visually impaired persons. We also have Anti-Counterfeiting Trade Agreement, ACTA. The ACTA is a proposed multinational trade agreement that would impose strict enforcement of intellectual property rights related to internet activities and trade information-based goods. Right now, the agreement is being secretly negotiated by government. I don't think it's still being secretly negotiated now. We must have established a baseline by now. The governments involved are United States, Japan, Switzerland, Australia, New Zealand, South Korea, Canada, the European Commission, and Mexico. Now, if this negotiation pulls through, if they adapted, if adapted, the treaty would establish an international coalition against copyright infringement, imposing strong and top-down enforcement of copyright laws in developing or developed countries. Okay? All right. Now, internet firewalls. Let's talk about something different now. I'm trying to combine a couple of topics today so we can finish our course material before our exams. I heard the exams is in May. So let's see how much as we can cover before that time. Now, in terms of internet, that is e-business, it's always important to understand internet firewalls. The internet firewall is a system or a group of systems that enforces a security policy between an organization's network and the internet. The firewall determines which inside services may be accessible from the outside of this government of the organization, which outsiders are permitted to access or are permitted to the inside services that are permitted to access outside services, which outside services are permitted to access inside services of an organization. So a firewall is just like a gatekeeper, like a gateman operating with a policy. The policy says, let this one in, don't let this one in. Let this one out, don't let this one out. Something like that. All internet traffic must pass through the firewall for inspection. The firewall should allow only authorized traffic and be resistant to penetration. Firewalls do not protect against attack that bypass or penetrate them. A firewall is part of a broader security policy, not just a device or a router. Security policies should include like user security guidelines and responsibilities, and all users of such as PCs or computers should be acquainted with such. Now, corporate policies on network and service access, authentications, encryptions, and virus protection are part of this entire security architecture we're talking about for e-businesses. Employee security training should be carried out and they'll be briefed on how these things work because one vulnerable employee can set the organization into a position that can put the organization in a position that they become open to attack. Now, a firewall without a comprehensive security policy is ineffective, like a steel door on a tent. Of course, you know it will not protect you from anything. Okay. So where are we? Limitations of firewalls. I hope that's where we are. Okay, we had limitations of firewalls. Where is it? Okay, yeah. Now we are the benefits of firewall. Sorry, my slide is acting up. But let me see if I can upload it again. Okay. All right. So that's about it for today. I don't know what's happening to my files, but maybe the firewall here is not working. Something is wrong. Something is wrong. All right. Let's just continue. Let's just continue. Okay. Well, let's continue. My file has just stopped working. It's like the internet is blocking it. Something is wrong somewhere. I don't know what it is. All right, like I said, the firewall is one of the things that protects the system from intrusion from outsiders getting in and from insiders getting out without proper authorization. Okay, that's about it. Let's call it a day at this point. We'll continue from the benefit of firewalls next time, in addition to event management in our next session. So it's important to log in and join for that particular session. All right, you can unmute yourself and ask your question at this point. If you have any challenge, let's talk about it. I got a mail from one of you that says he's having real challenges accessing the internet from where he is. I sympathize with you, but so what can I do? You have to find a good internet because this is an open and distant learning course, and it requires you to be online to make reasonable progress. Most of your courses are online, so you need to turn on the internet or find one or go to where one is. All right. So any questions? Let's talk about it before I shut down for the day.
Okay, good evening, doctor.
Good evening.
My name is Agbaje. Thank you very much for the lecture, sir. God bless you. My own concern is, please, can you please help us drop the soft copy of the lectures of this for this course on the WhatsApp platform so that we can easily, personally or individually download it and maybe print it out so that we can have access to it.
Okay, the course material, because
Yes,
the video will not be good. It's too heavy.
yes. I've been having that challenge with the video and all this stuff, but with the course material, the soft copy, easily I can print it out. I have printer in my house, I have in my office. So that I can
It's
really print.
easy. Just why not just type e-business and event management, NOUN PDF on your browser, and you will get the latest copy. All you just need to do is to check the
So the
copyright on
latest
it.
copy is not what they uploaded because I've been to Victoria Island to collect material. They said they don't have material. They said they are expecting from Abuja. The budget
That's
out
for
of 10
physical copy. That's for the
Yes,
physical
because
copy,
it's not
but the
online. It's not the latest, because anytime you are teaching, I try to look at that one that is online. It's not the updated version, sir.
okay.
Yeah, I asked them,
Okay.
it's not the updated
I will look
version.
through my system and see if I'll get that latest one and send it, I'll post it on the WhatsApp group. Probably you guys can share it as you like among
Yes.
yourselves.
The one online is not the updated version.
Okay. I should
Yes, sir.
have the updated one.
Oh,
Okay.
God bless you.
Another question. All right. All right. Then I'll see you guys next week. Thank you for joining.
Thank you very much, sir.
All right. Bye-bye.
Bye, sir. Have a
Bye
blessed
bye,
weekend.
sir.
Okay.